appeal in the matter of Bailey and Stonewall Equality and others.
Yes.
Thanks, my lady. I appear for the appellant, Alison Bailey, who was the claimant in the proceedings at first instance. My learned friend Mbala Casey appears for the first respondent, Stonewall Equality Ltd. The second and third respondents, as you'll appreciate, don't have a specific interest in this appeal, so are not represented, but I understand intend no discourtesy to the court. If it is convenient for your lordships and your ladyship, I'll refer to the relevant parties as the claimant, Stonewall and Garden Court, to try and keep things clear. And just by way of an indication of timings, we understand that we have a time estimate of a day and a half. I am intending to finish some point between 2:30 and 3 this afternoon, which should allow reasonable time for Ms. Mbala to reply, to respond, and a short period for reply if I need it tomorrow. This appeal concerns the ingredients for liability under Section 111 of the Equality Act 2010, which is at page 29 of the authorities bundle behind the first tab. It may be helpful just to turn it up and establish the structure of the provisions that we're concerned with and how the facts of this case fit within them. Section 111 is located within the overall structure of the Equality Act in Part 8, which is entitled Prohibited Conduct Ancillary. So as that suggests, this is an ancillary liability provision, ancillary to the primary forms of prohibited conduct. I'm going to come back in a little more detail to the overall structure and how that should inform the interpretation of this provision in due course. But you'll see from the terms of Section 111 at page 29 that what it does is make it unlawful for a person A, to do one of three things, well in fact four things, either to instruct another to commit a basic contravention, that's subsection 1, or to cause another person, B, to commit a basic contravention, or to induce B to commit a basic contravention, or pursuant to subsection 8, to attempt to cause or induce B to commit a basic contravention. So those are the four different ways in which liability may arise under the provision. And in each case, what person A has to have done is either brought about in one of those ways or attempted to bring about in one of those ways a basic contravention, so a primary form of liability by person B in respect of a third person, C. And the final aspect is that pursuant to subsection 7, there must be a relationship between A and B in which A is in a position to commit a basic contravention in relation to B. This claim specifically relates to the ingredients for causing a basic contravention under subsection 2 or inducing a basic contravention under subsection 3. There was a claim for instructing under subsection 1, which was dismissed, and there's no appeal in respect of that claim. The essential facts of this case and the way in which they fit within the scheme of section 111 are these. In the terms of section 111, the claimant is person C. So she is the person against whom the basic contravention was committed. The tribunal found that she holds gender critical beliefs, as well as beliefs about the damaging effects of Stonewall's campaigning on those issues, which constitute her protected characteristic of belief. She was a practicing barrister at Garden Court Chambers, which in the terms of section 111 is person B. Garden Court was in turn a member of Stonewall's Diversity Champions scheme, pursuant to which it paid an annual fee in return for various benefits, which meant that Stonewall was a service provider to Garden Court within the meaning of section 29 of the legislation. Maybe worth just turning that up at page 23 of the bundle. Pursuant to subsection 1 of section 29, a person, a service provider concerned with the provision of a service to the public or a section of the public for payment or not, must not discriminate against a person requiring the service by not providing the person with the service, or under subsection 2 as to the terms and manner in which the service is provided. And so Stonewall was therefore in a position to commit a basic contravention in relation to Garden Court for the purposes of subsection 7 of section 111. And in the terms of section 111, Stonewall is therefore person A.
Just pausing there, that I think was common ground below, but there may be an issue about it now in light of some of the findings made, so we'll come to that.
We'll come to, I think that there may be an issue that's raised in my learned friend's skeleton argument, which I'll need to address, and we'll come to.
Okay, this was all common ground, was it?
This was all common ground, yes. So on the essential facts which give rise to the relevant issue as to liability are that on the 31st of October 2019, Kieran Medcalf, who was head of trans inclusion at Stonewall, sent a complaint to Garden Court Chambers to, as the tribunal found, protest about the claimant's protected characteristic of belief and the various ways in which she had expressed those beliefs. That is, the complaint was about the relevant protected characteristic in this case. In that complaint, I'm going to come to the detail in due course, Kieran Medcalf invited Garden Court to do what is right and thanked them in advance for their time and consideration on this issue. Garden Court Chambers duly considered the complaint and decided what to do about it, and decided to partially uphold it. And in doing that, the tribunal found they directly discriminated against the claimant because of her beliefs. So in the terms of section 111, that is the basic contravention. And on the tribunal's findings, but for Stonewall's complaint about the claimant's beliefs and her legitimate expression of them, Garden Court would not have committed that basic contravention. It's common ground that but for causation alone is insufficient to establish liability for either causing or inducing under subsections 2 and 3 of section 111. The core questions on this appeal are: what are the additional ingredients and are they met? I'm going to focus in these opening remarks on the principal way we put our case, which is in relation to causation under subsection 2. And I'm going to come to the tribunal's reasons, but the tribunal did not spell out what it thought the additional element was. It's not apparent from its reasons, either its self-direction as to law or the reasons it gave, what test it thought it was applying. As between the parties and the EAT, there are, as I understand it, essentially 3 alternatives now proposed to this court. Alternative 1, the EAT's alternative, is that in addition to but for causation, what is required is an assessment of whether, having regard to the statutory context and all the facts, it is fair or reasonable or just to find A liable. We needn't turn it up at the moment, but for your reference, that's paragraph 123 of the VAT's judgment at page 71. But in my submission, that formulation, which is very open-ended, begs the question, what are the criteria by reference to which what is fair or reasonable or just is to be judged? And I will submit that the VAT offers no clear guidance. Indeed, it explicitly leaves the test open-ended. The second alternative is that Stonewall submits, as I understand it, that in addition to but-for causation, what is required is that A's actions must be a direct rather than an indirect cause of the basic contravention. And again, for your reference, that seems to be the submission at paragraph 41 of my learned friend's skeleton argument, page 281 of the bundle. But again, in my submission, that begs the question, what in this context are the criteria for deciding what direct means, given that direct, the language of directness or indirectness in the context of causation always begs the question, what sort of intervening act means that the causation is no longer direct? Certainly in my submission, given the inherent structure of section 111, the fact that there's an intervening basic contravention for which B is independently liable cannot of itself break the chain of causation, because that would render the whole structure inapplicable. But again, that begs that being the case, what you would have to decide if that were the relevant test is what are the features of any intervening act which might mean that it does break the chain. And in my submission, Stonewall's skeleton argument offers no guidance as to that. The third alternative, which in my submission is the correct one, is that the additional ingredients are to be found by reference to the underlying primary causes of action. The approach ought to be this: if A's actions have all the characteristics of the primary form of discrimination or other prohibited conduct in question, then by definition,
We'll say primary form of discrimination
or other form of prohibited conduct in question, then by definition they will be actions of a kind which it is the purpose of the Equality Act to prohibit within the fields to which it applies. And so if those actions with all those features cause B, in a but-for sense, to commit a basic contravention in relation to C, then it will follow that, having regard to the purpose of the legislation, those are circumstances in which it is fair or reasonable or just to hold A liable. Those are circumstances in which A ought to be liable. And they are circumstances in which the intervening basic contravention ought properly to be regarded as a direct cause, ought properly to be regarded as not breaking the chain of causation and in respect of the primary act of A. So you'll see it may be that there isn't a fundamental difference between us as to what we're looking for, but ultimately, in my submission, whichever of the routes to the solution one adopts, the answer is going to be the same. The answer has to be that it's the purpose of the legislation and the underlying features of the primary causes of action that ought to inform the additional ingredients, whether one describes that as looking for what is fair or just or reasonable, or looking for whether the intervening court ought to be treated, the cause ought to be treated as breaking the chain, etc. And in my submission,
Was that? Is there any authority on just that proposition that but for isn't enough? There has to be another component. So what we're looking at is what's the additional element? Has anybody looked at this before and dealt with this, or is that inferentially that must be so if you look at the legislation that but for, I mean, it couldn't possibly be all that you need under the causation element of section 111, because that would be crazy.
the answer is there is no authority that deals with this. So this is the first case before this court, or indeed any other court that's decided this, that can decide this matter. The essential reason why there must be something other than, well, let me take a step back. There may not be a requirement for anything other than but for causation in some cases. So, for example, where the underlying primary cause of action is indirect discrimination, there is no requirement other than that there be the application of a PCP, which has a particular objective effect. And so it may be that in a case of causing indirect discrimination, it would be sufficient that person A does something which causes person B in a but-for sense to apply such a PCP in circumstances where it's not justified.
Could you give an example in real life? That was all a bit statute book or textbook.
So an example might be if I am a supplier to a company A is a supplier to company B, and company A says, when you send your delivery drivers, I'd like them to be more than 6 feet tall because I have high shelving that they need to be able to reach. And a tribunal finds on the facts that there would be ways of working around, providing steps and other means of accessing the higher shelving, which means that that's not a justified criterion. It doesn't matter what A's intentions are, it doesn't matter whether A foresees that this is discriminatory or not. It's simply sufficient that A has caused B to apply that criterion in deciding who to employ for that purpose, and that has a disparate impact as against women. So that would be, I appreciate it's all fairly hypothetical, but that would be an example of the way it might work. But it's not necessary for the court to decide finally, in this case, what would be the ingredients in a case of causing indirect discrimination. The issue here is what are the ingredients in the case of
direct discrimination,
yes,
which is our territory.
Exactly. And in direct discrimination, plainly in my submission, having regard to the purpose of the legislation, it's not sufficient just to have but-for causation, because in those circumstances you could easily find person A being liable, having had no improper motivation
That's my
themselves.
point. So they could be an innocent, we
Yes.
could call them, and unless there was this additional requirement, they could be swept in as a tort
Yes.
fee, because they might have done something that had caused B to commit the basic contravention, and
Yes.
that would just shake all your senses of what a tortious,
Exactly.
a statutory tort should be doing.
Exactly
You're
right.
looking for something with I'm trying to leave it vague at the moment because you'll land me on this, something with a sort of wrongdoing flavour to it. There has to be something to get A into this circle.
Precisely that. Yes. And in my submission, the approach I've outlined provides a clear and consistent basis for identifying the additional ingredients in a way that enables them to be identified by any putative wrongdoer, by any duty bearer, and by any court. It does so on a basis which properly and closely ties liability to the purposes of the statute, which is to eliminate conduct with all of the characteristics of discrimination or other prohibited conduct from the spheres in which the Equality Act applies. So, in the case of causing direct discrimination on this approach, the ingredients of liability will be these: that A does something because of a protected characteristic.
You take it slowly again. A does something because of a protected characteristic.
That being one of the core elements of direct discrimination under section 13. And what A does is detrimental to C in some way, that being the other key aspect of direct discrimination, plus but for causation. So but for those things, B would not have discriminated against C, but because of them, B does directly discriminate.
What do you mean by detrimental in some way if you don't mean but for causation?
I mean that what A does is inherently less favourable and detrimental in relation to C.
Forgive me, I've gone back to section 13. Those components, or A and B, are in section 13, are they? The idea that you in a bipartite situation, A does something because of the protected characteristic,
Yes.
and then you said that which is detrimental.
Yes, I should perhaps have used the term less favourable rather than detrimental, but it amounts to the same thing. So it's all in subsection 1,
Yeah.
page 10 of the bundle. Person A discriminates against another B if, because of a protected characteristic, so that's the improper motivation. It doesn't have to be conscious, it doesn't have to be intentional, but if it's because of a protected characteristic, then that requirement is met. A treats B less favourably than A treats or would treat others. So, to put it more concretely in the terms of this case, on the tribunal's findings, there's no doubt that Kieran Medcalf, on behalf of Stonewall, sent the complaint because of the claimant's protected characteristic of belief. It was explicitly to complain about those beliefs and their legitimate expression. There can also be no doubt that it was a detrimental action in relation to C, claimant. If you, as party A, write a complaint about somebody, that's detrimental. And there can also be no doubt that it's less favourable treatment than Mr. Medcalf would have engaged in relation to somebody who did not have the claimant's protected beliefs. Because he wouldn't complain about somebody who expressed beliefs about which he didn't have the same prejudice and objection to their employer.
But intention is not an element. You say you could be unintentionally.
You can be unintentionally.
This way because you do something that factually causes the detriment.
Yes.
That's to less favourable treatment, and in fact, it is because of their protected characteristic.
Yes. And it's a general principle of direct discrimination law that you don't have to have that conscious intention to discriminate. The relevant case, it may be helpful just to turn it up, since we've touched on this point now, is well-known case of Nagarajan and London Regional Transport, tab 4 of the authorities. And the relevant passage begins at page 884 of the report 55 of the authorities bundle. It's the whole of the sideline red passage, but just to highlight the key points in just below letter E. Lord Brown Wilkinson says, in every case it's necessary to inquire why the complainant received less favourable.
Sorry, where are you?
Just below letter E on page 884 of the report.
Lord Nichols.
Sorry, yes, you're right, Lord Nichols. In every case it's necessary to inquire why the complainant received less favourable treatment. This is the crucial question. And then at letter G, that is to be distinguished sharply from a second and different question, which is if the discriminator treated the complainant less favourably on racial grounds or other protected grounds for our purposes, why did he do so? So what you're looking for is the underlying, whether there's an underlying link to the protected characteristic, not the conscious or ostensible motive for that. And then if I turn on 2 pages to page 886, just below between letters E and F,
Sorry, there's a problem with mine, so I'll go
Sorry.
for my copy.
and I should perhaps just pick up at paragraph, at page 885 at letter E, the indication there that the basis for the direct discrimination, for the motivation being because of the protected characteristic, may be subconscious. It doesn't have to be a conscious motivation. And then at page 57, the bundle 886 of the report, above letter E, decisions are frequently reached for more than one reason. Discrimination may be on racial grounds, even though it's not the sole ground. Variety of phrases used. And then at letter F, the central test is whether racial grounds or protected acts for victimisation had a significant influence on the outcome. So Nagarajan is authority for the propositions that the question is not what is the conscious motive of the discriminator. The question is simply, was racial grounds or other protected characteristic a significant influence on the actions in question? So liability for direct discrimination will be established even if the discriminator didn't consciously intend to discriminate, if because of the protected characteristic they do something which is less favourable treatment and in fact detrimental to the claimant.
Can I just check? I was just checking my notes. Do you then read that? You say that operates at B to C level as it operates at the A to B level?
Other way round. So it operates at the A to B level as it operates for the purposes of section 111, as it operates at the B to C level for the purposes of the
Sorry, I put it rather badly.
direct discrimination against
mirror image. You say it's the same thread that runs through.
Yes.
That's the liability thread.
Yes. And so in my submission, the answer to this case ultimately depends on 3 propositions which are indisputable on the tribunal's findings. Firstly, that Stonewall, acting through Mr. Medcalf, acted because of the claimant's protected characteristic of belief. Secondly, that it acted in a way that was less favourable and detrimental to the claimant. And thirdly, that but for those actions, Garden Court would not have directly discriminated against the claimant in relation to the partial upholding of the Stonewall complaint. So that's really the core of my submissions to the court. I propose to develop those by taking you through 4 areas. First of all, the core relevant factual findings of the tribunal. Secondly, and really at the heart of it, the correct interpretation of section 111. And then thirdly, the tribunal's reasons and errors, which will cover grounds of appeal 1, 2 and 5. There's Amabala notes in her skeleton, and I agree that the primary focus is on whether the tribunal got this right, not on whether the AT got this right. But I will deal briefly at the end, and fourthly, for completeness, with the EAT's additional errors. But I take those fairly swiftly, I hope, at that stage. So, beginning then with the relevant factual findings of the tribunal, I'm going to start with some general background and then address 4 sets of key factual findings, which in my submission are central to, indeed dispositive of the appeal. In terms of the general background, and turning to the core bundle and the tribunal's judgment, picking it up, initially paragraph 1 on page 86 of the core bundle. At the time in question, the claimant was a practising barrister doing criminal defence work and a member of Garden Court Chambers, paragraph 1. There's an introduction to Stonewall and its status and position at page 98 of the bundle. Beginning at paragraph 54, you will see Stonewall is a large and widely respected charity whose stated mission is to advance the rights of gay, lesbian, bisexual and trans people. The widely respected epithet in that description is, in my submission, important to note in the context of some of the points taken against me, particularly the EAT's position in relation to foreseeability. As that description and the other findings of the tribunal show, Stonewall has been a hugely successful and influential campaigning organisation, reflected in the successful campaigns listed at paragraph 54 on behalf of lesbian, gay and bisexual people, and also reflected, for example, at page 58, paragraph 58 over the page, by the fact that many organisations had signed up to its diversity champions scheme. So when asking if it is ever relevant, and in my submission it's not, but if it became relevant to ask whether it's reasonably foreseeable that a complaint by Stonewall might have an influence on an organisation like Garden Court, Stonewall's status as a widely respected organisation with that level of influence across many organisations is a relevant factor. From around 2015, as you'll see at the end of paragraph 54, Stonewall changed its focus to transgender issues, and at paragraph 55 set up the Stonewall Trans Advisory Group, with the acronym STAG, to formulate a 5-year plan. I'm noting that because that provides some of the context in which the complaint was sent, and it's useful to know what the acronym stands for. That change in direction caused, as the tribunal found at paragraph 59, tension among some of Stonewall's traditional supporters. As the tribunal notes, lesbians in particular felt threatened that males who identified as women would have access to same-sex spaces and alienated when they were told that it was transphobic if they objected to that. And additionally, some lesbian and gay men regarded gender recognition as incompatible with their rights in the form advocated by Stonewall. The claimant was one of those people, and I'll come to her beliefs in more detail shortly. Conversely, Garden Court was one of the organisations that joined the Diversity Champions scheme, and you have some findings about that at paragraph 61 on page 100. It joined the scheme in November 2018, and you'll see there, in return for an annual fee of £2,500, received a number of benefits, including a dedicated account manager to advise on best practice, conduct client meetings with chambers and stakeholder groups, free places at Stonewall seminars, use of Stonewall's Diversity Champions logo, copies of Stonewall's publications, etc. Much of the tribunal's fact-finding about the background is not directly relevant to this appeal, and you'll be pleased to hear I'm not going to spend time going through the detailed background. The immediate factual context that is relevant for the matters that we're concerned with is that on the 22nd of October 2019, the claimant sent a tweet in response to and in support of the launch of an organisation called LGB Alliance. That is at paragraph 130 of the judgment, page 116. And you see there the terms of the main tweet, which in very reduced terms essentially kicked off the issues which have led to this complaint. The claimant simply tweeted, "This is an historic moment for the lesbian, gay and bisexual movements. The LGB Alliance launched in London tonight, and we mean business. Spread the word. Gender extremism is about to meet its match." That extraordinarily generated, as the tribunal describes it in paragraph 132, a strong reaction on Twitter, some of which was specifically directed to Garden Court. It also generated various complaints made through Garden Court's website, which the majority of which are described in paragraph 136 on page 118. But those complaints did not at that stage include the Stonewall complaint. Over the ensuing days, there was a lot of internal communication within Garden Court about what to do between the heads of chambers and senior staff and others within chambers. Again, the details of that need not trouble this court. Save to note that one of the things that Garden Court did on the 24th of October 2019 at paragraph 155, page 124, was to send out a reply tweet to a number of individuals in the expectation it would then be retweeted, indicating that Garden Court were investigating concerns raised about Alison Bailey's comments in line with our complaints / BSB policies. We take these concerns very seriously and will take all appropriate action. Views expressed in a personal capacity do not represent the position advocated by Garden Court. And the tribunal found that that was one of the acts of direct discrimination by Garden Court. It's not one of the acts caused by Stonewall or induced by Stonewall, but it's relevant to the background for reasons that I'll come to. So that was the first act of direct discrimination by Garden Court. Another of the things that Garden Court did was to commence an investigation into the complaints that had been sent through its website, which was to be carried out by one of its members, Maya Sickand. And at paragraph 177 on page 129, you will see that the request was made to Ms. Sickand to investigate those complaints on Friday the 25th of October, and at 182 you'll see over the page, you'll see that on the 29th of October the policy and the relevant complaints were sent to her. She fairly quickly reached the conclusion that there was nothing to investigate in relation to the complaints received up until that point, and you find that at paragraphs 187 and 188 on pages 131 and 132. In particular, the final sentence of paragraph 188, overall, her conclusion is there was nothing to investigate. So that was the state of play when Kieran Medcalf, on behalf of Stonewall, made this complaint on the 31st of October 2019, and against that background, I now want to focus on the four key sets of factual findings that in my submission are dispositive of the liability in this case. The first set of factual findings is in relation to the claimant's beliefs and what is protected in this case. The central proposition that I'm going to derive from the findings is this, that not only are the claimant's beliefs protected as the protected characteristic of belief under Section 10, but none of the relevant tweets or other communications in which she expressed those beliefs breached any of her professional duties as a barrister or otherwise objectively justified any action against her. I don't understand this to be in contention, but it's important to set the foundation of the appeal. The relevant beliefs of the claimant are set out by the tribunal at paragraph 279 of its judgment at page 157. I shan't read them out, but you will see that in addition to what might be described as the core gender critical belief that sex is real and observable and that gender, by contrast, is a subjective identity, measurable and observable with no objective basis. In addition to that core gender critical belief, the claimant also held a set of beliefs about the severely detrimental effects of Stonewall's campaigning on this issue, both at letters D through to F, in relation to its implications for women and lesbians in particular. So the denial of women's safe spaces, letter D, denial of the legitimacy of same-sex attraction, and in particular pressure being placed on lesbians to have sex with straight men who identify as lesbians at letter E, and the particularly damaging loss of Stonewall as an effective advocate for its original constituency of lesbian, gay and bisexual people at letter F. And also in relation to the labelling of those who oppose Stonewall's position as bigots and the succour that had given to abusive and threatening behaviour to people who express dissenting views at letter C. The tribunal find, and it's not been appealed, at paragraph 293 on page 161, that all of those beliefs that I've just referred to are protected within the protected characteristic of belief under Section 10 of the Equality Act. So when one is asking whether treatment was because of that protected characteristic, it is all those beliefs that one has in mind.
You said a few minutes ago you were going to focus on four key findings of fact.
Yes.
Is this number one?
This is number one, yes. So this is my core proposition that I'm deriving from this set of findings is both that all of the claimant's beliefs are protected, and all of the ways in which she expressed those beliefs in various tweets and other communications are protected because they were not objectively such as to justify any restriction on them. So the first part of that I've been through, and then the second part is, you can see by picking it up at paragraph 295 on page 161, where the tribunal correctly directed itself that if Garden Court acted because of a particular manifestation of the claimant's beliefs, the tribunal would then need to consider whether any such manifestation or expression was properly separable from those beliefs, which in this context meant deciding objectively whether or not the manner of expression or manifestation hit a level of inappropriateness that justified a relevant restriction. And unless the court would like me to, I don't propose to take up time going to the authorities that have now developed in that area. The most recent is Higgs and Farmers School. My Lord Justice Bean will be familiar with the result in that, but that has affirmed that the approach the tribunal took here was the correct approach. And indeed, there's been no appeal in respect to the tribunal's approach in that regard. And so, in respect of all of the tweets and other communications which had variously been suggested were inappropriate, the tribunal noted ultimately only 2 of them were taken forward with any sort of adverse finding, and the tribunal carefully considered those 2 tweets. Again, because of the finding, I needn't take up time going through them. At page 170 of the core bundle, in the last 8 or so lines of paragraph 327, towards the top of that page, the tribunal considers the question of separability. It finds, first of all, as a fact that, picking it up 1, 2, 3, 4, 5 lines down on the page, that Garden Court respondents did not make their finding because of the manifestation of the claimant's belief, even in such forceful terms, breached BSB guidelines in such a way as to cross the limitations in Article 9 or 10. When it was not conduct, they were obliged to report, and they did not heed the claimant's explanations of intimidation or coercion.
Sorry, just going back 4 lines. Garden Court respondents did not make their finding. Which finding?
This is the end of the tribunal's conclusion on the basic contravention that we are concerned with. So the
By GCC, by the...
Garden Court's finding that Garden Court discriminated by partially upholding the Stonewall complaint, and I'm going to come back to the more detailed findings in that regard. But just in respect of this point about whether the claimant's expression or manifestation of her beliefs on which Garden Court focused crossed the line, you have, first of all, in the passage I was reading, the finding that the Garden Court respondents didn't make their finding because it crossed the line. And secondly, and ultimately in the last sentence of that paragraph, we the tribunal, did not understand what she had said to harm the reputation of others to the extent required to limit the application of Article 10. So the tribunal itself found that nothing the claimant had said was sufficiently inappropriate or objectionable to merit any restriction on her right to say it in those terms. And again, no appeal against that. So that's the conclusion of my first core area, which establishes the...
So that's a really funny way of putting it, isn't it?
It is. It is just a funny way of putting it.
But you say that's a finding, that the mode of expression of these protected beliefs didn't cross the line.
Yes. Okay. And that you can tell that in more detail if you look, for instance, at paragraphs 322 and 323, beginning on page 167, 168. Perhaps would it assist if I just take the court through the 2 tweets and the various findings in relation to them, if this is potentially a matter of concern for the court, or
yes, by all means.
Just to set the scene slightly, the court will be aware that at the material time there'd been a consultation on gender self-identification, and that was the context in which a lot of this communication was taking place. The 2 tweets that were in issue can be seen, first of all, at paragraph 118 on page 114.
Is this 5 and 17? Is that what we're going to? Is that what the numbers were? Because they were in a schedule as well, weren't they? Maybe that doesn't help. Maybe that doesn't help. I don't want to distract you. Let's go. Let's stay where we were. Where were we going? Paragraph from the judgment.
Paragraph 118.
Okay.
It's indeed number 17.
So it was 17 on the 22nd of September, a tweet that Stonewall
You
recently
don't have to
hired.
read it out. We found it.
Okay, cool. And then at paragraph 171 on page 128, was the other of the two tweets that were ultimately in issue. And then, in relation to those two, you will have seen that the claimant was asked during the internal investigation by Garden Court to provide her explanation in relation to those tweets, for the purposes of then enabling Garden Court to assess whether what she said was a reasonable view in relation to the underlying facts, or whether it in some way crossed the line. And in respect of the first of those tweets that I took you to, that was number 17, you'll find a summary of the claimant's explanation at page 140, paragraphs 214 to 216. And so essentially in relation to that tweet, the claimant's explanation was that her understanding of the term cotton sealing was a reference to women's underwear and the barrier that presented to trans women, natal men, who wished to sleep with lesbians, and that her reference to coercive behaviour was the coercive effect of labelling lesbians as bigoted if they declined to have sex with male-bodied people. That was the claimant's explanation in relation to that tweet. And her explanation then in relation to the other is set out at 217, and the essential explanation was that the claimant regarded both the tone of Stonewall's own rhetoric, no debate, trans women are women, no debate, and Stonewall's failure to step up and condemn the sort of abuse and threats that were being levelled extensively at anyone, particularly women and lesbians who spoke out on this issue. She regarded that as making Stonewall culpable for that sort of action. And the tribunal itself then considered those explanations and Garden Court's treatment of them in relation to the allegation of discrimination against Garden Court in upholding the Stonewall complaint. It did so at paragraphs 322 and 323 at pages 167 and 168. And again, I don't propose to read out those two paragraphs, but what you can see there is a careful, the tribunal's doing two things through a careful consideration of the tweets. On the one hand, it's considering whether Garden Court's treatment of those two tweets and its consideration of them was a reasonable approach as part of its fact-finding to decide whether to draw an inference that Garden Court discriminated. But the tribunal is also identifying, in particular, the claimant's explanation in respect of each of those two tweets was a reasonable explanation which meant that Garden Court paid proper attention to it and taken proper account of it through the process, Garden Court ought to have also recognised that it was a reasonable explanation. So that's a roundabout way, coming back to my ladyship's question, that the final sentence of paragraph 327 is an odd way of putting it, I would accept, and is a little cryptic. But when you see it in the context of all the discussion up until that point, together with the tribunal's self-direction that what it needed to decide, amongst other things, was whether any particular manifestation that was relevant crossed the line so as to justify being restricted, it's a clear finding to that effect. And as I say, I don't understand that to be in dispute. That's the starting point for where we are. So ultimately, that brings me to my conclusion on the first of my 4 areas of key factual findings, that all of the beliefs and all of the relevant manifestations and expressions of those beliefs that we are concerned with were protected as part of the protected characteristic of belief under Section 10 and under the Equality Act. The second key set of factual findings are in relation to the context in which Kieran Medcalf wrote the Stonewall complaint. And the central proposition that I'm drawing from these findings is that Kieran Medcalf wrote the Stonewall complaint in response to explicit encouragement to write to the heads of chambers at Garden Court to complain about the claimant's beliefs, because they, the heads of chambers, were considering formal action against her. Could I pick up the relevant findings in that regard at paragraph 133 on page 117 of the judgment, please, of the bundle, please?
117.
Page 117, yes, paragraph 133. You'll see there on Wednesday, the 23rd of October, there was a meeting held by a group of, it's the Trans Organisations Network is what TON stands for, a group of organisations that supported self-gender identification, run by the LGBT Consortium, and Sean, it was chaired by someone called Sean Nan, or Knan, who you will see from roughly a third of the way through paragraph 133, was a STAG member, so a member of Stonewall's Trans Advisory Group, and had organised the meeting in his capacity as an employee of the LGBT Consortium. And prior to the meeting, he had learned from Michelle Brewer, a member of Garden Court, that, and I'll read from the tribunal's findings about 2/3 of the way through that paragraph, she told him, so Michelle Brewer told Sean Knan, that people who had concerns about the claimant's social media posts could send a complaint to the heads of chambers. She added that she had already raised concerns with the heads of chambers and they would be looking into it at a chambers meeting on Monday. And then...
Him is the Sean Knan, is it?
Yes. And then at paragraph 135, you will see what the minutes of the meeting showed, top of page 118. Sean Knan telling the attendees, which included Kieran Medcalf, that the community was encouraged to write to Garden Court chambers heads in the next couple of days, expressing concern about Alison Bailey's barrister transphobic comments on Twitter. Chambers have a meeting to decide on formal action against Alison Bailey. Sean to send an email to roundtable participants. And the tribunal concludes in the passage just below that those were an accurate record of the meeting. The next thing that Sean Knan did at paragraph 137 at the bottom of the page, was later on the 24th of October to send a message on the Stag Wall, which was a private messaging service provided by Stonewall and accessible to members of the Stag, which included Kieran Medcalf as well as Sean Cannan, as well as on the Stag Facebook page, which is another private page used for communicating between members of that group. He said in that message, Alison Bailey of Garden Court supported the anti-trans LGB alliance just launched. Garden Court had always been allies, and Michelle Brewer had flagged the issue internally to the heads of chambers, presumably a reference to an email that the tribunal was aware of. And then there's a quotation of what he said: there will be a meeting on Monday with the head of Garden Court Chambers to discuss if any formal actions against Bailey should be taken. He had spoken to Michelle Brewer, who told me she encourages the trans community to write messages of supporting action against Bailey to the heads of chambers, and he asked people to write by Monday morning. I should add for completeness, the tribunal found that he was mistaken about Michelle Brewer giving that encouragement, but that was what he said to the participants at the meeting. If we then go on to paragraph 189 at page 132, you will see that Kieran Medcalf sent his complaint on the 31st of October, but the tribunal finds in line 3 of 189, the complaint seems to have been drafted on the 28th of October when he posted on the Stag Wall, done, referring to Sean Cannan's appeal there to send messages of support, with a comment adding that he had found an earlier offensive tweet, probably the Morgan Page one. So the tribunal's clear findings are that Kieran Medcalf was prompted to send the complaint by those encouraging remarks made by Sean Cannan. The context in which he sent the complaint was an encouragement to object to the claimant's expressions of her belief because they were, quote, transphobic, and because chambers were considering formal actions in relation to her. So whatever his subjective intentions in sending the complaint, he must have understood, because it was explicit in the material that prompted him, that an investigation and formal action of some kind were a possibility.
And Mr. Cannan is not an employee of Stonewall.
No.
Employee of LGBT Consortium.
Yes.
Which includes Stonewall but others as well.
Yes.
But he was a member of Stag.
Yes. Yeah. So there were complaints before the tribunal on behalf of the claimant in relation to Mr. Cannan's actions as well. Those depended on him, Stonewall, being vicariously liable for his actions, and the tribunal found that Stonewall wasn't. So those complaints fall away and there's no appeal in respect of that. But that's not material for these purposes to this complaint, because there's no dispute that Kieran Medcalf's actions were on behalf of Stonewall. And the relevant point I'm making is not that Sean Cannan was doing things in a Stonewall capacity, but simply that what he said which prompted the actions of Kieran Medcalf. So when assessing what Kieran Medcalf must have understood or what inferences are to be drawn in respect of his actions, there is no doubt that he was responding to encouragement to complain about the claimant because her beliefs were, quote, transphobic, and there is no doubt that he was doing so in a context where he had been told the heads of chambers were considering taking formal actions against her. He then, that's the second set of findings. The third set are in relation to the complaint itself and Kieran Metcalf's reasons for writing it. The core propositions which I'm going to draw from these findings are these, that Kieran Metcalf wrote the complaint, firstly, because of the claimant's protected characteristic of belief. Secondly, to the extent that it matters, his intention in doing so was to protest to a perceived ally about the claimant's protected characteristic of belief and its legitimate expression. And thirdly,
Sorry, because we're into the protest point now. So you say his intention doing so was to protest to a perceived ally about. Could you just give me those words again?
about the claimant's protected characteristic of belief and its legitimate and protected expression. And thirdly, he explicitly invited that perceived ally to consider and take some action without, on the tribunal's finding, having a clear intention as to what precise action that might be.
Okay, can you give us the references for those three elements? The middle one is paragraph 377, isn't it? What's the first one? That the
So,
finding that the email was sent because of the claimant's protected belief.
I'll take you through the findings, but it's also it's also 369 and 377 read in the overall context, because I'm using the phrase "because of" there in the sense of definition of direct discrimination. So it was because precisely because it was about the claimant's protected characteristic of belief. And the perceived ally point is also paragraph 377. The invitation to take some action is, I'll take you to it, but that's the terms of the complaint itself, the express objective terms of the complaint, and the lack of a clear, a specific aim is 369.
But that's it. That's his evidence. 369 recites the witness's evidence.
Yes, and it's, as I understand it, accepted at 377. Effectively, his evidence in that regard is accepted.
I mean, the finding is that what he wrote was no more than a protest with an appeal to a perceived ally in a them and us debate.
Yes.
So are you going behind that finding, or trying to go behind that finding, and saying there was a bit more to it, saying it was an invitation to take action?
I'm not going behind that finding insofar as that is a finding about his intentions. I am going to take you to the terms of the complaint itself, which explicitly invites.
The ET went uphill and down Dale looking at as well, and I read that this is where they came out.
Well, it depends if you read that as a So if that is a finding about his intentions, I don't seek to go behind it. If that is an attempt to characterise the complaint itself as not even inviting some consideration and action of some kind, then it's plainly contrary to the objective terms of the complaint itself. And indeed, to the tribunal's own recording his evidence at paragraph 369, its own description of his evidence at 369, because the qualification, except perhaps a public denial of association with her views, plainly indicates that Kieran Medcalf himself was saying he anticipated potentially some sort of action. When I say consider the complaint and take some action, I'm not saying consider the complaint necessarily and take some formal action. I'm just saying he didn't expect Garden Court to do nothing with it. So the starting point for the set of findings here is paragraph 60 at page 100. Where you have a finding in the last 3 lines of the paragraph as to Kieran Medcalf's views in relation to gender critical belief and objections to gender self-ID. So his position, as recorded by the tribunal, is that objecting to gender self-ID was of itself transphobic, hatred of trans people, though he distanced himself from threatened assaults. Now the reason I start there is just to highlight that that is a commonly held prejudice against people with gender critical beliefs, that those beliefs are inherently transphobic and bigoted, and that the people who express them are therefore guilty of transphobia and bigotry. Could I, in that context, just invite you to look in the authorities bundle at the case of Miller and the College of Policing in the Court of Appeal, tab 15, beginning at page 549. You may recall this is the case where the claimant, Mr. Miller, had been had a non-crime hate incident recorded in respect of him because of some tweets he'd sent on this subject expressing gender critical views. The details don't matter. The reason I'm going to the case is, first of all, at paragraphs 35 and 36 in the judgment of Dame Victoria Sharp, page 564 of the bundle, 5002 of the report.
I'm sorry, I found that my authorities bundle, this one anyway, and goes up to page 459.
We have a spare, my lord.
If you have a spare of 460 to the end, that would be wonderful. many thanks to whoever made that sacrifice. I'll return pages 1 to 459, if I may. Yes. So, page.
Page 564 of the bundle.
Thank you.
Dame Victoria Sharp is here discussing some of the evidence accepted by the first instance judge, and in particular that of Professor Kathleen Stock, who was then Professor of Philosophy at Sussex University, about the cancel culture and climate of fear. You'll see those references at letter E, faced by people who hold and express gender critical beliefs. Letter F, she says some of those involved in the debate label those with different views as transphobic or displaying hatred when they are not. They're intolerant of different views, even when expressed by legitimate scholars whose views were not grounded in hatred, etc., but are based on legitimately held different value judgments and form part of mainstream academic research. She then discusses the evidence of Professor Stock, giving the example of trans women are men as being an objective statement from the perspective of those with gender critical beliefs and not a statement of indicative of transphobia. And right at the bottom of the page, on the other hand, trans advocacy groups such as Stonewall explicitly define transphobia as the fear or dislike of someone based on the fact they are trans, including denial of or refusal to accept their chosen gender identity. And then at paragraph 76 on page 575, she, based in large part on that evidence, concludes, third line of paragraph 76, that Mr. Miller belongs to a group of people who could easily be stigmatised for their opinions and be subject to complaints by those offended by his views. And then the other authority I just want to briefly touch on in this context is this court's judgment in Higgs and Farmer's School. And I can take the point, I think, relatively briefly by going to page 751 of the authorities bundle. This was the case, we'll recall, where the claimant had expressed gender critical beliefs and conventional Christian beliefs about same-sex relationships in online tweets and publications, and was dismissed by the school that employed her. This court found unlawfully because the way she'd expressed those protected beliefs hadn't been objectively unreasonable. But in that context, and this was entirely obiter, but in that context, at paragraph 172, Lord Justice Underhill set out some submissions the court had received from the Equality and Human Rights Commission in relation to prejudice and stereotyping of people who hold beliefs of that kind, and how that may treatment of them, unfavourable treatment of them because of such prejudice and stereotyping, may be unlawful discrimination. So in the inset quotation at paragraph 172, on one particular species of direct discrimination, which an employee holding or manifesting their belief might have significant influence on their treatment, is through the putative discriminator's adoption of a stereotype. In such a case, although the reason for the treatment given by the employer is not the protected characteristic, it's nonetheless positively relied on by the claimant. The claimant argues that the decision maker has consciously or unconsciously adopted a stereotype and was significantly influenced by it in deciding on the treatment complained of, i.e. on the basis that the claimant would share the perceived attributes of the group rather than relying on evidence about a particular individual. If that is then to be the treatment, if that is so, then the treatment will be because of the protected characteristic. It does not matter if the stereotype is very likely to be true. In relation to religion or belief, a decision maker will accordingly discriminate where the reason given for the treatment is significantly influenced consciously or unconsciously by a stereotype that the persons who hold or manifest the relevant belief will share attributes of a group which they might not in fact possess. Examples of stereotypes in relation to religion or belief explicitly recognised in the case law are that persons who hold or manifest certain gender critical beliefs have an animus towards trans people. And then the remainder discusses other possible beliefs and stereotypes. And Lord Justice Underhill says immediately after the inset quotation, I'm prepared to say, albeit entirely obiter, that my provisional view is that that is a correct summary of the law. So the reason I've taken a little time going to those points is that the starting point here is that the view which Kieran Medcalf held of the claimant's beliefs is precisely that sort of prejudice or stereotype in relation to gender critical beliefs. And it's precisely the sort of prejudice or stereotype which the Court of Appeal in Miller recognised was liable to expose people in the claimant's position to unjustified complaints. And precisely the sort of stereotype or prejudice that the Court of Appeal in Higgs, albeit obiter, recognised as liable to give rise to unlawful direct discrimination if acted upon. I turn then to the terms of the complaint itself. It's in the supplementary bundle for the appeal. The tribunal will see there are two versions of it at pages 2 and 3 and then 4 to 5. That's because Mr. Medcalf sent it twice. He sent it to the Chamber's website and then also 10 minutes or so later sent it to the Chamber's various Chambers clerks' email addresses. So he was clearly determined that it should get through.
The substance is the same.
The substance was the same.
Yes.
So I'm going to take the version at pages 2 and 3
Yes.
because it's the one that comes first. And the substance starts about a third of the way down page 2. So contacting you within my role as head of trans inclusion at Stonewall, therefore no dispute by Stonewall that he's acting on their behalf in sending this complaint and they're liable for his actions. To raise concerns regarding barrister Alison Bailey and her association with yourselves. Now, just pausing there, and again, in my submission, his conscious intentions aren't relevant, nor is foreseeability. But if foreseeability is relevant, then whatever his conscious intentions, he must have thought about the terms of this complaint and ought to have appreciated, when one looks at that objectively, that on the face of it, he is objecting to Garden Court continuing to associate with the claimant. Then you have reference to the claimant's Twitter account and the general introductory statement to the various aspects of his complaint that via her Twitter, she has been making and retweeting multiple transphobic statements online, including, and then there is a set of examples, unless the court is inclined to, we needn't go through every single one, but they are all characterised by repeatedly describing the expression of the claimant's gender critical beliefs as being transphobic or as denying the rights and existence of trans people. So there's objection to describing trans women as men. There's objection to objecting to their access to women's spaces or women's prisons. And then 2 paragraphs up from the bottom of the page, there's then a further introductory paragraph specifically targeting Stonewall and our members of staff, and there's then a set of examples where the claimant is expressing her beliefs about Stonewall, which, as I took you to are part of her protected belief, and then again characterising her chairing of a women's place meeting as being associating with a hate group, fourth paragraph down on page 3. So
That should be woman's place, should it?
should be woman's place, yes. So explicitly and on their face, all of those complaints are because of the claimant's belief or their legitimate expression. It doesn't matter what was going on precisely in Kieran Metcalfe's mind consciously, because it's inherent in what is said in this complaint that he is acting and making the complaint because of, explicitly because of, the claimant's protected beliefs or their legitimate expression. And he then goes on in the final 3 paragraphs to say these actions and their link to Garden Court Chambers threatens the positive relationship yourselves have built with the trans community through holding events, etc. Ms Bailey's actions are also in direct conflict with the fantastic work your barristers such as Alex Sharp have done on the GRA reform. Garden Court barristers have always been allies to trans people and to Stonewall, something we're very proud and grateful for. However, for Garden Court to continue associating with a barrister who is actively campaigning for a reduction in trans rights and equality, while also specifically targeting members of our staff with transphobic abuse on a public platform, puts us in a difficult position with yourselves. The safety of our staff and community will always be Stonewall's priority. I trust that you will do what is right and stand in solidarity with trans people. Thank you in advance for your time and consideration on this issue. So, just pausing there, I don't need, for the purposes of my case, to say that, or to establish that Kieran Metcalfe had any particular intention in mind, or that he, let alone that he specifically intended that Garden Court should treat this as a formal disciplinary investigation and potentially take formal disciplinary action against the claimant. But what is undeniable, and indeed is not denied by Kieran Metcalfe in the evidence recorded by the tribunal, is that he didn't intend nothing to happen about this. Plainly, that's not the case. He explicitly invites the heads of chambers of Garden Court to devote time and consideration to the complaint, to think about it and think what should be done in relation to it, and do something, do what is right. So presumably, since he had no specific outcome in mind, do whatever they thought was right in relation to this complaint. So far as any question of foreseeability is concerned, and again in my submission, not relevant, but in case it is also relevant to note what the objective meaning of what is said is, because Kieran Metcalfe ought to have appreciated the objective meaning and the possible actions in relation to this, whether in fact he subjectively did or not. And the objective meaning of the words that Kieran Metcalfe chose to use were that for Garden Court to continue associating with the claimant put Garden Court in a difficult position with Stonewall. And that Garden Court should therefore consider acting in respect of that, having devoted time and consideration to this issue. So, as I say, none of that is essential to my case. The only point that is essential to my case, 2 points that are essential to my case, are that Kieran Metcalfe acted and wrote the complaint because of the claimant's protected characteristic of belief and its legitimate expression, and that the complaint itself was plainly less favourable and detrimental to her. To have an organisation of the nature of Stonewall write to your employer, in this case quasi-employer Chambers, accusing you of transphobia in circumstances where that they obviously wouldn't do that, but for the claimant's beliefs, they are less favourable treatment because of her beliefs, is plainly less favourable and detrimental treatment to her, not least because it plainly does invite some response by Garden Court which is liable to be detrimental to the claimant. So just to take a step back, if Garden Court had done the thing that the tribunal says Kieran Medcalf perhaps thought they ought to do, if they had responded to the invitation to devote time and consideration to this complaint by considering it, agreeing with Mr. Medcalf that the claimant's various expressions were transphobic, and giving a public statement to that effect, we disassociate ourselves with Alison Bailey's transphobic public statements, transphobic tweets, there can be no doubt that that would be directly what Mr. Medcalf was seeking and had in mind, and would be detrimental to the claimant. So on any view, this was a complaint which was, because of her protected characteristic, it was on the tribunal's findings at paragraph 377, a protest about that protected characteristic, and it was made because Kieran Medcalf perceived Garden Court as sharing his hostility, his prejudice in relation to the claimant's protected characteristic of belief, an appeal on the tribunal's findings to a perceived ally. Those in my submission are findings which are sufficient in and of themselves to establish liability on the correct test, which I'm going to come to shortly. But the last area that I need just to address in terms of the tribunal's findings is the impact that the complaint had in respect of Garden Court's conduct. And the core propositions or conclusions of fact that I draw from this set of findings are firstly that but for Kieran Medcalf's complaint, Garden Court would not have discriminated against the claimant by upholding that complaint in part. But also, Kieran Medcalf was right that the key decision makers at Garden Court shared his hostility to the claimant's protected characteristic of belief, and that prejudice influenced their decision. And although he himself was not aware that Garden Court were diversity champions in the tribunal's finding, the complaint was in fact received and considered by Garden Court, having regard to the context and existence of that relationship, and that indeed influenced their reaction to the complaint. So first of all, as to but for causation, that's dealt with again at paragraph 377 of the tribunal's reasons, page 184, given the point that the process in relation to investigating the claim had reached at the point that the complaint was made by Kieran Medcalf, that was an inevitable finding, because otherwise it's clear that nothing further would have happened in relation to any of the claimant's tweets by way of investigation or outcome. And then in relation to the primary or basic contravention itself, could we go back to paragraph 327 on page 169, please?
Yes.
The first third of the paragraph recites some of the tribunal's findings about the process and criticisms of the process, and then the final set of inferences that the tribunal draws based on all of its findings up to this point begin at, it's about halfway down the big chunk on page 169, there's a line that begins, was her views that influenced this decision. And then I would like to pick it up with the next sentence that begins, Stephanie Harrison also contested. So Stephanie Harrison also contested Maya Sicken's initial milder conclusion, which might have led to a different report back to the claimant. Ms. Harrison had already demonstrated her opposition to the claimant's views about trans rights and about Stonewall, had herself recognised she should not be involved. It's hard not to infer that her own view on gender-critical feminism as hostility to trans rights played a part in this decision. So there you have a finding which, in effect, is that Ms. Harrison, in the part she played in this decision, shared Kieran Medcalf's hostility to the claimant's views, his prejudice about the claimant's views, and that hostility materially influenced Garden Court's decision. Then Maya Sickand, initially neutral, had shown hostility to the claimant's 2nd November tweets about Stonewall, and seems to have been influenced by Garden Court being a diversity champion, though Kieran Medcalf's complaint made no mention of this. From this, we can infer that disapproval of the claimant's beliefs about Stonewall informed her sense that there must be some breach of the core duties here. So, again, a clear finding indicating that Maya Sickand is considering this complaint and the issues that it raises in the context of, by reference to Garden Court being a diversity champion, and indeed that fact influenced her finding in relation to the complaint. And then the tribunal turns to the heads of chambers. Even though one of the heads had reservations about finding on tweet 2, all approved it without discussion. Judy Khan had shown little patience for the claimant in respect of the December 2018, in fact it was an email about Stonewall, or the launch tweet and discussions about it. So had Leslie Thomas. There is then reference to some of the previous complaints and how they had been dealt with differently, and then the passage that I took you to that deals with, amongst other things, how whether the tweets were objectively objectionable. And then at 328, from these matters, so all of the various matters the tribunal has referred to in relation to all the participants in the decision, we conclude that the claimant's gender-critical belief, and in particular her belief about Stonewall's promotion of gender self-identity, encouraging and being complicit in hostility to gender-critical feminists, significantly influenced the finding that her 2 tweets were likely to breach core duties. So all of those matters, but in particular the fact that at least Ms. Harrison, as one of the decision makers, shared Kieran Medcalf's hostility to the claimant's beliefs, and at least Ms. Sickand, as one of the decision makers, was materially influenced by the fact Garden Court was a Stonewall diversity champion and was considering the complaint in that context. Those matters led the tribunal to the inference, the finding, that the outcome of the Stonewall complaint was itself an act of direct belief discrimination.
Finding here means finding by a sick hand.
Yes. So to draw together the effect of the core findings that I've taken you through, and this is set out at paragraph 6.4 of my skeleton argument, page 21 of the bundle. If one reduces down those findings to their essentials and puts them in terms of the structure of section 111, the features which you have in this case are that because of A's prejudice against C's protected characteristic, so Kieran Medcalf, Stonewall's prejudice about the claimant's beliefs, A, Stonewall, complained to B, Garden Court, whom he perceived as sharing his view of that characteristic, and did so, elaborating slightly, because of and in order to protest about that characteristic itself. I'm just pausing there before I come on to the second part of my formulation there. It's impossible to imagine, really, any constellation of features which is more culpable in the Equality Act discrimination sense. If one is looking for features of wrongdoing, features which contravene the basic purpose of the Equality Act, doing something unfavourable to an identified person, not only because of their protected characteristic, but to complain about their protected characteristic to their employer, is about as culpable as it gets. And in response to that, person B, Garden Court, who, as it turns out, does share A's hostility or prejudice against the characteristic and was influenced by their relevant relationship with A, directly discriminated against person C, the claimant, by investigating, considering, and in part upholding the complaint. And again, whatever Mr. Medcalf subjectively thought he was doing, the idea that it is not the very sort of thing that Garden Court might do on receipt of a complaint to consider it, decide if it's right, and if they think it's right, uphold it, is absurd. Of course that's the very sort of thing that anybody in receipt of a complaint of that kind is likely to do, not least...
That wasn't what the Employment Tribunal found. Are you inviting us to draw inferences or make findings to that effect? Because I see where you're going, and some of this is in the tribunal, but they don't put it together like that at all. There are no findings about, as far as I can see, I may have missed it, this constellation of features inevitably led to Garden Court conducting the investigation. It's absurd to argue otherwise.
Well, again, I hope I've been clear. In my submission, the point about foreseeability is not an essential point. The only points I need on my submission are points which are there on the face of the tribunal's reasons. So, point one, this was a complaint by Kieran Medcalf because of the claimant's belief, to protest about that belief. That's definitely there. Point two, whatever his intentions, it's necessarily and objectively a detrimental and less favourable act by him. So his intentions are not relevant, and in my submission, it's obvious. I don't know how to put it more differently or better or more cogently, but it's obvious that if you send a complaint to someone's employer, particularly if you're in the position that Stonewall was in relation to them, that's a detrimental act. It's a less favourable act. He would not have sent that complaint but for the claimant's protected beliefs, and it was something that was inevitably detrimental to her, irrespective of what his subjective intentions were. And if the tribunal was focused on other things and didn't identify that point and deal with it, that's an error of the tribunals. But it's an error that is it's a gap that is easily filled because the point is obvious. And if you're against me, but come on, to outcome. But if you're against me on that,
I'm entirely open-minded about this case. Obviously, I suppose I just slightly cavil at speaking for myself. If all you need were these basic reductive components, that there has to be a complaint about the protected characteristic belief, and that was on an objective basis a detrimental and less favourable act. I mean, there you are. I've got those points on board, and we can. Why do we go? Why are we being treated to the elaborate advocacy about the obviousness that it was all part of him trying to get Garden Court Chambers to reopen the investigation, and you can't. I've written down your words. It's impossible to imagine any constellation of features which is more culpable. I mean, that's not what the tribunal found. That's my simple point.
No.
So
Well,
obvious, you'd expect them to have found it, and they didn't. They actually found something rather. They took a rather different tack.
well, that's. So I don't need to go as far as saying that he intended to do it. I'm not seeking to go behind those findings, but Your Ladyship earlier on this morning put to me that is the thread that we're looking for, something that is wrongdoing within the terms of the Act. So I was, perhaps in slightly colourful terms, addressing that point in those remarks, that it was a flowerier way of simply putting the same point, that what he's doing is something that is very obviously has all of the characteristics of direct discrimination that the legislation is intended to eliminate within the spheres to which it applies.
I mean, in terms of what the tribunal did find, you see in 377 in the passage that it's obviously much to be debated, we concluded that it was no more than protest. As to what the tribunal meant by that, I suppose 369 does help. In the sense that the protest at least encompasses writing without any specific aim in mind, except perhaps a public denial.
Yes.
So it must at least include the possibility of getting a public denial.
Yes. That's so far as the intention is concerned, but
You said that intention doesn't matter, but
No.
if you are thinking about what the tribunal found in terms of intention, that's what you do find.
That's what you do find, is that it's a protest without a specific intent. A protest with an appeal to a perceived ally in a them and us debate, without a specific intention in mind, save perhaps a public disavowal or denial.
You read that so public denial by GCC, do you, rather than
Yes.
him putting on record his own denial of
Yes.
Does it come to this? Look, if I got this wrong, 377 has 4 sentences. The first one you're happy with.
Yes.
You say that establishes but for causation.
Yes.
The second, you say you disagree with it, and you say it doesn't apply the correct legal test to make. It's
Yes.
a matter of submission. And the third is a question, you say it's the correct question. But the fourth, we concluded it was no more than protest with an appeal to a perceived ally and them and us debate. You're saying that can only be understood as an examination of his Mr. Metcalfe's mental processes, which he had told the tribunal about it, as recorded in paragraph 369.
Yes.
They appear by inference to accept what he said,
Yes.
but you say that isn't right in law. Even if his intentions were to do no more than protest, you argue that the email has to be read objectively. Is that a summary of what you say about 377? Don't say yes just because I've said it.
So
I just want to understand.
mostly yes.
Yes.
On the last sentence, I suppose I would put it this way: it's the no more than, implying that that's a reason for rejecting the claim, to which I object. So I would say it was a protest with an appeal to a perceived ally in a them and us debate, and that is enough to establish liability, because the effect of that finding is that what he was doing was something, because of the claimant's protected characteristic, that was less favourable treatment of her and detrimental to her, and therefore had all of the characteristics of direct discrimination. So that the finding that it was a protest about her protected characteristic, and perhaps I can try and sort of put some colour on this in this way. Having done a number of cases in this area now and addressed tribunals on them and talks on them, and by no means suggesting that this is this court's approach, but there's sometimes an implication that there's something different about belief discrimination compared with the other characteristics. And whatever you decide about the way that this legislation, this provision must work in relation to this case, has to work for other characteristics as well. And I would suggest not that it is very unlikely we would be here if one substituted a different characteristic for belief here. If one had a situation in which an influential organisation wrote to an employer with whom there was a relationship, wrote to the employer saying, I object to your employee C, Mr. C, kissing his partner on the way into work every morning because I find it disgusting that you allow same-sex relationships. And then that employer investigated employee C, his kissing his partner on the way into, his male same-sex partner on the way into work every morning, and partially upheld it because without a good justification, because the employer shared the dislike and distaste for the same-sex relationships. There's absolutely no way we would be here. And so the law has to work for all forms of discrimination and all characteristics, and there is not a hierarchy here. Belief discrimination, protesting about somebody's protected characteristic of belief is no less objectionable than protesting about their race or their sex or their sexual orientation or their disability or any of the other protected characteristics. So that's why I do the exercise of seeking to strip this back to its essentials, because it removes the cloud that sometimes belief discrimination can have around these issues, the fact that it's a protected characteristic of belief, and many people do still think this belief is objectionable. But that is not, in any sense, a defence to conduct done in the context of relevant relationships, which the Act seeks to eliminate.
Going back to my Lord's question about para 377, just going through the sentences, for my part, this is very helpful. You don't like the first sentence we've agreed on. The second sentence you say is the wrong question.
Yeah.
I think the third sentence is a bit the wrong question as well. It's not far off, but the issue was not whether the letter was an attempt to cause discrimination against the claimant, because I think on your case you say you don't need to go that far, because that's sort of tending into subjective intent. What you say is all that one needed to establish was whether it met the section 13(1)(2) criteria, and then going to the fourth sentence, and I have your point on this, you say that what is said there has got the components of that. You say that's enough.
That's the point.
But what the tribunal is plainly, as I read it, doing is it asked itself a question, which may be the wrong question in the third sentence. Was the letter an attempt to cause discrimination against the claimant? Answer, no. We have concluded it was no more than a protest. So in other words, that's where you, I'm just trying to get at your attention. That's where you say the slightly wrong question, certainly wrong answer.
Yes. Yeah. And
Now, in your case, one has to ask whether those last two sentences, which you say are wrong, informed the second sentence, which was the key conclusion.
yes. Exactly right. And it is opaque what test the tribunal thought it was applying.
But we can't sit here and read it like a statute.
No,
because
no.
Life's not like that, and you know
No,
that
of
we have
course.
to. Well, obviously, we've looked at this whole judgment, and we'll do the best. We try and understand where it was the tribunal was going, but it is just helpful to have that forensic analysis.
And it's perhaps I'm jumping ahead slightly within my structure here, but as we come on to it, I don't want to come back to all of this later because it will feel like Groundhog Day. Perhaps I should just make a couple of very brief points about the way that the case was presented to the tribunal and the things that it was dealing with. So first of all, before the tribunal, it was common ground that in addition to but-for causation, it should be asking itself, was the treatment in question significantly influenced by the protected characteristic in the direct discrimination sense that the elements of liability should mirror those of the underlying cause of action. And you can see that in the tribunal's self-direction at paragraph 360, page 180. Where you will infer from the absence of any, this was argued one way by one party and another way by another party, that this was a matter of common ground before the tribunal. And I don't want to overdo this because I'm not as it were taking a pleading point, but on behalf of Stonewall, no alternative additional ingredient was spelt out explicitly for the tribunal to think about. Submissions were made that the tribunal should find on the facts that there wasn't any basic contravention wasn't caused by what Stonewall did, but there wasn't this forensic debate that we're having about what any other proposed additional ingredient. So as it were, I don't entirely criticise the tribunal for not identifying any other ingredient, but say to the extent that if it was going to introduce one, it was sort of incumbent on it to say what it was, because we are now left a little bit in the dark given the way the case was presented. The other remark I'll just make about the way the case was presented is that you will have seen from the more detailed findings that follow through paragraphs 368 and then 371 to 376, that the tribunal was very focused on intention, whether Mr. Metcalfe knew that Garden Court was a diversity champion and those questions. And again, I don't criticise the tribunal for spending time considering those as factual questions, because the court will appreciate that two things. We were having to make submissions to the tribunal, both about the possibility of considering the Section 111 claim in circumstances where the tribunal had found a basic contravention was committed, and in circumstances where the tribunal hadn't found that, and we would be relying on an attempt to cause a basic contravention. So specifically on the attempt issue, I was submitting to the tribunal that they should find that Kieran Medcalf knew about the Diversity Champion scheme, was deliberately attempting to exploit that in a deliberate attempt to have Garden Court dissociate themselves from the claimant. Those were factual findings that I was inviting the tribunal to make. And the second point the court will appreciate is that on factual findings, you also seek to put your highest possible case to the tribunal so that there can be no doubt about the result if you succeed on that factual case. But equally, I was explicit, I made it very clear that if the tribunal found that detriment 4 was made out in respect of Garden Court, i.e. that Garden Court directly discriminated against the claimant by upholding by partially upholding the Stonewall complaint, then it would be sufficient to establish liability under Section 111(2) in that regard, that the Stonewall complaint was made because of the protected characteristic, and that it had resulted in that outcome on a but-for basis. So those were my explicit submissions to the tribunal. So whilst I make no criticism of the tribunal for spending time dealing with my high point case and my alternative case on attempt, where I do criticise the tribunal is in not addressing that part of the way the case was put and not giving any clear explanation as to why it thought, given its findings about protest, that that was not sufficient to establish liability, because it does leave us in the position where we don't know what test the tribunal thought it was applying. It doesn't direct itself as to any other test, and it's not apparent from the somewhat curtailed and cryptic language at paragraph 377 what it thought the test was. What it does show, and it is clear that the tribunal thought that it was not enough that Kieran Medcalf acted because of the protected characteristic, and that but for his actions the discrimination wouldn't have occurred. But it doesn't spell out, you know, the phrases like the occasion no more don't spell out what the tribunal thought the additional ingredients that were missing were.
Unless you do take the next two sentences as a guide to that.
Yes, that's probably the best you can do, and that would suggest that the tribunal thought that the additional ingredient was some sort of conscious intention on the part of Kieran Medcalf to bring about a particular consequence, in which case, in my submission, it would plainly be wrong. Come on to that.
Is the question they should have asked themselves. I'm just trying to track through. So is the paragraph 360 question, was Kieran Medcalf significantly influenced by her protected characteristic, and did detriments occur because of that?
Yes.
Yeah.
Precisely right. That brings me then to what I say is the correct approach to interpreting and the correct interpretation of section 111. I'm going to again divide my submissions here into four parts. The first part will be relevant principles of statutory interpretation. Second, matters of general context in relation to the location of section 111 within the statute and its structure, the structure of in terms of the section itself. Thirdly, in light of 1 and 2, the correct interpretation of causing under subsection 2, and then fourthly, the correct interpretation of inducing under subsection 3.
Just before you get underway on section 111, just on section 1117 relationship, I have in front of me paragraph 359 of the tribunal, page 180. Claimant's claim is Stonewall instructed, etc. On section 1117, there must be a relationship. The claimant says Stonewall was a service provider, and that's sufficient to establish a relationship. They don't say anything about whether that was agreed by the respondent or whether they put forward an alternative interpretation.
That was agreed by the respondent, that there was a relevant relationship.
It wasn't a finding. I think the ET didn't go back to it and say this was common ground. But I think that was your skeletons for this court that it was.
Yes, and just for your reference, at page 256 of the bundle, paragraph 4 of Stonewall's amended grounds of resistance.
Sorry, paragraph page
256.
Yeah.
Paragraph 4 of Stonewall's amended grounds of resistance. You'll see there the admission.
Yes.
Now, there is, I'll be guided by the court, there is on the face of my learned friend's skeleton argument, if I could just ask you to look at that at page 279 of the bundle, paragraphs 30 and 31. There's a point raised there about scope of the relevant relationship with, as I understand it, a suggestion that
Sorry, I've got lost. Where
page 279 of the core bundle.
which one is it for? The other side skeleton?
Yes.
Ah.
It's paragraphs 30 and 31 on internal page 8 of the skeleton.
and it comes back in 55, I think.
I think it does, yes. So there's a point raised there about that. Since we've been slightly diverted off onto scope at this point, it might be convenient. No, I'm not complaining at all. It's useful to be prompted to deal with some of these points. Would it be helpful to deal with that at this point? I've got some short points to make about that.
So we're on section 111.
If you'd rather not, then come to it later in your section 111 submissions, but if you're happy to deal with it now, deal with it.
I'm happy to, it's a discrete point really,
Yeah.
so I'm happy to deal with it now. This is not, doesn't arise from the issues of interpretation that are at the heart of this case. So there are 4 points I make in relation to that submission on behalf of Stonewall. The first is that whether the conduct of Mr. Medcalf was within the scope of the relevant relationship or sphere covered by the Equality Act is a different question from the issue in this appeal as to the ingredients of liability and causation. The tribunal did not, on any view, dismiss the section 111 claim on the basis of any discussion of whether the actions were within the sphere of the relationship or not. And Stonewall has not appealed on that separate issue. So that's the first point. The second point is that, on the contrary, in her opening submissions to the EAT, Ms. Omonbala explicitly conceded that the tribunal had found and that Stonewall had not appealed that the complaint was within the scope of Stonewall's relationship with Garden Court. That's the second point. The third point is that Ms. Omombala was right to make that concession and is wrong now to suggest in the skeleton argument that Mr. Medcalf's lack of subjective knowledge about Garden Court's diversity champion membership is material. And the reason she's right is because the authorities indicate that whether something is within the scope of a relevant relationship or a relevant sphere of the Equality Act is not dependent on the subjective view of the alleged discriminator as to the capacity in which he's acting, but on the capacity in which the action is received and experienced by the person who is the putative victim of discrimination, or in this case it would be Garden Court as person B, on whom person A's actions were operating. And that the authority for that proposition is Tip Lady against Bradford Metropolitan District Council, beginning at page 460 of the bundle. That was a whistleblowing case, but the question is essentially the same. Sorry, I'll let the Lordship find it. The issue in that case was whether the claimant, who was both an employee of the respondent council and had complaints about issues arising in relation to her own property, whether the acts of discrimination, acts of whistleblowing detriment she was complaining about fell within the employment sphere for the purposes of that legislation. The principles would be the same in relation to the Equality Act, as is apparent from the judgment. And at paragraph 45 on page 478, Lord Justice Underhill identifies the question as being how exactly a detriment is to be recognised as arising or not arising in the employment field. In this context of our case, it would be whether the complaint was arising or written in the context of the service provision field. And he says, just above letter D, broadly the test suggested by Mr. Lewis to the Employment Tribunal on behalf of the employer, and which it accepted, of asking in what capacity the detriment was suffered, or to put the same thing another way, whether it was suffered by the claimant as an employee, seems to me likely to produce the right answer in the generality of cases. This is not strictly the same as the two hats analysis, which Mrs. Tiplady challenges, because the focus is not on the hat being worn by the employer, but on that being worn by the employee. But in practice, these may be two sides of the same coin. But I do not think the boundaries of the employment field should be drawn narrowly. And then he goes on to identify a thought experiment to ask whether a complaint would be under the services provisions or the employment provisions of the Equality Act in order to decide which sphere it falls under. So the key proposition is it's the capacity of the employee or the capacity of the, in this instance, Garden Court that matters, not the capacity or subjective position of Kieran Medcalf. Obviously, Garden Court can't know the internal divisions of responsibilities between diversity champions' responsibilities and other responsibilities within Stonewall, or in what capacity Mr. Medcalf thought he was writing. So the fourth relevant point, therefore, is the finding I've already taken you to, that on any view, Garden Court considered the particular Ms. Siccan considered the complaint in the context of the diversity champions relationship and was influenced by that. So in my submission, Zomabala was right to make the concession that she did before the Employment Appeals Tribunal. It's not now open to her to say something different, but in any event, the matter is disposed of by the tribunal's findings on the authority of tip lady, and there's been no appeal in respect of those. Can I go back then to the correct approach to the principles of statutory interpretation as a precursor to saying how I submit section 111 should be interpreted? The most recent and helpful articulation of the relevant principles in my submission is to be found in the For Women Scotland judgment of the Supreme Court, because they set out those principles comprehensively and also identify specifically the purposes and considerations applicable to the Equality Act 2010. Begins at page 756 of the authorities bundle. And the court will be aware that the issue in that case was the meaning of sex. It's not, not the issue that we're concerned with. Paragraph 9 of the judgment of Lord Hodge and Ladies Rose and Zimler at page 762 sets out the general principles of statutory interpretation. In the inset quotation from R.O. against the Secretary of State for the Health Department, the courts conducting statutory interpretation are seeking the meaning of the words which Parliament used. Statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in the particular context. Words and passages in a statute derive their meaning from their context. Phrase or passage must be read in the context of the section as a whole, and in the wider context of a relevant group of sections. Other provisions in a statute and the statute as a whole may provide the relevant context. They are the words which Parliament has chosen to enact the expression of the purpose of the legislation, and therefore the primary source by which meaning is ascertained. And then I turn over the page to paragraph 10 of the judgment. In Quinterville, Lord Bingham warned against giving a literal interpretation to a particular statutory provision without regard to the context of the provision in the statute and the purpose of the statute, stated the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose, so that controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context. And at paragraph 11, the court emphasised that where there is sufficient doubt about the specific meaning of words, which the court must resolve, the indicators of the legislature's purpose outside the provision in question, including the external aids, must be given significant weight. If I could then take the court to paragraphs 112 and 113 at page 787. What I'm going to do now is just go through a few excerpts and then draw the principles that I want to from them. So paragraph 112, EA is an important piece of legislation with a wide scope, regulating the conditions and relationships and interactions between private individuals and both public and private entities over a field of activities that ranges from, and there's a description of some of the different fields in which the legislation operates. It's both an amending and a consolidating statute, which was intended, amongst other things, to reform and harmonise equality law, restate the greater part of the enactments relating to discrimination and harassment, related to certain personal characteristics. I'm skipping then to the last couple of lines, and to strengthen the law in order to support greater progress to equality. So wide scope and purpose of the legislation identified there. And then at page 790, paragraphs 130 and 131, at 130, the Act operates to protect both individuals and groups of people who share a protected characteristic from unlawful discrimination. And 131, at an individual level, it does so primarily by means of a general prohibition against less favourable treatment in the form of overt or direct discrimination because of one or a combination of individual protected characteristics. So that's the central form of discrimination prohibited in relation to individuals. And then at page 795, paragraphs 151 and 152, it's clear that the Equality Act 151, the Equality Act gives important legal rights to individuals and groups who are vulnerable to unlawful discrimination because of a particular or shared protected characteristic. And then 152 imposes duties on individuals and organisations not to discriminate unlawfully, does so by regulating the practical day-to-day.
This is all pretty familiar territory.
It is,
I think,
yes.
but if you can anchor it in the facts of the case, that
Yeah.
would be helpful.
Well, let me draw out the points that I was going to draw out from those provisions.
Yeah.
First of all, the Equality Act is both a consolidating and amending statute, so should be construed on its own terms. That's relevant to section 111 because it's a new provision in the Equality Act that had some analogues in the earlier legislation, but they varied in content and scope, and so we look at section 111 on its own terms. Secondly, the Equality Act is an important piece of legislation with wide scope. I won't go to it, but my Lord Justice Bean in particular will be familiar with Jones and Tower Boot.
Yes. Though Lord Justice Waite's observations in Jones and Tower Boot mustn't be compressed into claimants always win their case.
No, of course. But it does say in terms that the purpose of the legislation is to eliminate the very great evil of discrimination in the spheres to which the legislation applies. And that's reinforced by the passages that I was going through in for Women Scotland.
Yeah.
That this is a statute of wide scope that should be construed in the case of any doubt broadly by reference to that purpose. And it's really one of the points at the heart of my submission on interpretation, because my essential point is that where the conduct of person A has all the characteristics of discrimination which the Act is intended to eliminate within the spheres to which it applies, those are the circumstances in which, in addition to but-for causation, it would be fair and just and reasonable to hold person A liable. One central purpose is to protect individuals who are vulnerable from unlawful discrimination in the spheres to which the Act applies, from individual detriment because of protected characteristics. That's direct discrimination. And the last point is that because this is a statute that needs to be understood and applied consistently and practicably across a range of different duty bearers, across a range of different fields, there does need to be a touchstone for them to know with a degree of certainty, am I allowed to do this thing or not? And I'll come on to it, but the effect of both of the tests proposed by the EAT and by my learned friend, without clear touchstones, is that effectively you can only decide after the event whether what person A has done has the characteristics that give rise to liability or not. And that's not really an acceptable way of this piece of legislation operating. My lords, my lady, it's 4 minutes to 1, and that
Depends on
It's interesting.
what one's looking at. Oh, yes. After 20 years of working in this building, I learned that every clock gives a different message.
so if that would be a convenient point.
We'd like to break off.
Can I just say thank you to whoever prepared the electronic bundles of authorities, because they're all the relevant paragraphs. are individually bookmarked, and it's really, really helpful, and I've not seen that before, so thank you. Yeah. Well, there you are. I didn't know I was handing you the bouquet.
Right. Well, we'll return at 5 to by that clock.
All rise in favour.